Our justice system starts from the moment the police apprehend a person suspected for the commission of crime. For this reason, the police is considered as the initiator of the system. The arrest of the suspect may be with a warrant of arrest or by warrantless arrest. If the person was apprehended with warrant, the prosecutor will conduct a preliminary investigation for the determination of probable cause that may warrant trial before a judicial court. However, if the person arrested was apprehended without warrant, an inquest proceeding must be observed. When we say preliminary investigation, it is an inquiry or proceeding to determine whether there is a sufficient ground to engender a well-founded belief that a crime has been committed and the respondent is probably guilty and should be held for trial. The court having the jurisdiction of the case will schedule the arraignment for the accused to enter his plea. However, the accused may file a motion to quash complaint or information under Rule 117, Section 1 of the revised rules of the court at any time before entering his plea on any grounds under Section 3 of the same rule. If the motion to quash is based on an alleged defect in the complaint of information which can be cured by amendment, the court shall order that amendment be made. But if it is based on the ground that the facts charged do not constitute an offense, the prosecution shall be given by the court an opportunity to correct the defect by amendment. When motion to quash is granted, the court will order that another complaint or information be filed against the accused for the same offense. But if it is denied, schedule for an arraignment will come into place. Upon arraignment and plea of the accused, a mandatory pre-trial conference under Rule 118 will commence to take up the following matters: plea bargaining, stipulation of facts, marking for identification of evidence of the parties, waiver of objections to admissibility of evidence, modification of the order of trial if the accused admits the charge but interpose a lawful defense, and such other matters as will promote a fair and expeditious trial of the criminal and civil aspects of the case. After pre-trial, the court issues an order reciting what has been taken, and thereafter, the trial on the merits will proceed on the matters not disposed of during pre-trial. Upon trial on the merits, adjudication by the court that the accused is guilty or not guilty of the offense charged, and the imposition of the proper penalty and civil liability, if any. Correction will now come into place after judgment of conviction. Correction or rehabilitation is divided into two approaches: the institutional correction and non-institutional correction. When the accused is sentenced to serve not more than 6 years of imprisonment, he may be filed an application for probation. The President of the Philippines may also intervene in the exercise of his power of executive clemency by granting either absolute or conditional pardons to the convicts. Another community-based correction program may be availed by the convict known as parole. However, under this program, the convict needs to serve at least minimum of his indeterminate sentence in prison before he may be qualified under this program. If the convict does not qualify for non-institutional corrections, he will serve his sentence in a correctional institution. There are two bureaus handling institutional corrections: the Bureau of Corrections and the Bureau of Jail Management and Penology. Those convicted of not more than 3 years of imprisonment will be placed under the Bureau of Jail Management and Penology, and those sentenced exceed 3 years will be rehabilitated under the Bureau of Corrections. After the service of the sentence either under institutional or non-institutional correction, it is presumed that the convict is already reformed and fit to be released to the community as a law-abiding citizen. And that's how the process of criminal justice system in the Philippines works.